cooperation is kindly appreciated. Without further ado, I would like to introduce our moderator for today's talk, Ms. Shirlene Tong. Ms. Shirlene is a partner in the International Arbitration and Litigation team Withers Worldwide, where she is currently based in Hong Kong. She is a specialist in cross-border corporate and commercial disputes, such as joint venture and shareholder disputes, pharmaceutical disputes, commodities dispute, to name a few. International commercial arbitration, international contracts, and multi-jurisdiction litigations. She acts as a counsel, sits as arbitrator, and as an expert on international arbitration procedures. Her unique background and legal experience have effectively given her the ability to be involved in all roles of a dispute. She started her remarkable career in Switzerland with leading independent arbitrator, Dr. Pierre A. Carrier, where she acted as tribunal secretary for several complex international commercial disputes and assisted with expert legal opinions. She then worked for the ICC, International Court of Arbitration, in both Hong Kong and New York, managing more than 300 international arbitration matters. She is currently appointed as a permanent member of the ICC International Court of Arbitration's National Committee Nominations Commission for Hong Kong. I shall now pass the floor to Ms. Shirlene Tong to introduce the speakers for today. Thank you so much.
Jason, thank you very much. That, I think, unfortunately set not a very good precedent, because we have four very impressive speakers before us today. I will not be going into that much detail into their background, because this is something that I think everyone in the audience will be able to look up in their profiles. In addition to introducing them, I'm going to kind of give the audience a background or a flavor of today's roundtable discussion. If I happen to impede on any one of our speakers' discussion today, I'm sure they will just merely take what I say and elaborate. So as everyone here today knows, we are here to speak about the New York Convention, which in its very long phrase is the Convention on the Recognition and Enforcement of Foreign Arbitral Awards. Now, an interesting fact is that as of January 2023, with Timor-Leste, I should know better how to say this given that I am Asian, with that contracting party signing or ratifying the New York Convention, we are at 172 contracting states as of January 2023. It is one of the key instruments in international arbitration, and it applies exactly to what the name says, right? The recognition and enforcement of foreign arbitral awards, and basically referral by a court to arbitration. So the reason why the New York Convention is so impressive is because there's really no global counterpart to the New York Convention when it comes to foreign court judgments. So most major states, including the US, are not parties to any bilateral or multilateral agreements where there's an agreement to enforce a foreign judgment, which is why it's one of many benefit of why parties should choose international arbitration when trying to resolve their disputes. Now, as you can see from the title and the introduction given by Jason, the purpose of today was to speak, whether or not the New York Convention is actually a paper tiger, or is it actually effective? Interestingly enough, all of our speakers today who are extremely experienced in arbitration, dispute resolution, and have significant experience in enforcing awards, they, to my understanding, all believe that it is an effective enforcement mechanism and not necessarily a paper tiger, and they will give you their experience why. But one of the reasons, and for example, the thing that I like to actually raise to my clients or my students when I explain, take a look at a more what we would sometimes call troublesome jurisdiction. I hope I don't get in trouble by anyone. I always like to use Saudi Arabia as an excuse, because none of my clients really trust the courts of Saudi Arabia, and they also doubt whether or not arbitration actually works. But interestingly enough, in 2021, the courts of Saudi Arabia had enforced 204 domestic and foreign arbitral awards, which represent an aggregate value of over 2.1 billion US dollars. And the average enforcement proceeding in Saudi Arabia for these awards will resolve within an average of 2 weeks. So, and don't get me wrong, the Saudi Arabia Arbitral Center, which is a great center run by a very wonderful gentleman, they're also in the process of revising their arbitration laws. But to me, and I'm sure what the panel will explain today or relay to you today, shows that the New York Convention and international arbitration really are effective. Now, I'm going to now give the introductions, which again will it does no justice by Jason again, but hopefully the speakers will be happy with what I say. First, you're going to hear from Mr. Tariq Khan, who is a seasoned disputes practitioner with significant experience in domestic and international arbitrations, and he's currently the registrar of the International Arbitration and Mediation Center in Hyderabad. Mr. Khan was formerly a partner of Avani Law in New Delhi, and he is currently an adjunct professor at Nalsar University of Law. Now, when Mr. Khan speaks, he will speak on his experience in India and the surrounding jurisdictions. Following Mr. Khan will be Dr. Nasser Mazen Al-Adba, who is the current chair of CIARB Qatar QFC branch. He's an assistant professor of investment arbitration at Qatar University and managing partner at Omani and Partners. Dr. Nasser, or Dr. Al-Adba, was also the legal advisor to the president of the Olympic Committee, and he's an expert on sports law. Dr. Al-Adba will speak on his experience in the Qatari and the Middle East region in respect to enforcement of arbitral awards. Thereafter, we will have Mr. Oliver Bolthausen, the Global Deputy Head of Dispute Resolution at DWF and the Managing Partner for Germany. Mr. Bolthausen is a renowned dispute resolution specialist and a highly experienced arbitrator and mediator. Mr. Bolthausen is educated in both the common law and civil law, and he also currently serves as the legal counsel, let's see how good my German is, legal counsel to the Deutsche Stiftung Mediation, which is basically the German Foundation for Mediation. Now, Mr. Bolthausen will obviously speak about his experience in Germany, but also in the surrounding European region. And last, but of course not least, we have Mr. Edmund Cronenberg, who is currently the managing partner of Bradel Brothers, which is actually Singapore's second oldest independent law practice. Mr. Cronenberg has had over, oh, you're going to hate it when I say it this way, over a quarter of a century's experience in dispute resolution, litigation, and arbitration, and he's regularly appeared as lead counsel in cases before the Singapore High Court, the Court of Appeal, and of course, arbitrations. Mr. Cronenberg also sits as an arbitrator, and he will focus on Singapore and the ASEAN region. Now, just a kind reminder to the audience, we will have our 4 brilliant presentations, and thereafter we'll take a quick break, and then we'll reconvene for the Q&A session, where I do highly suggest, please type any and all questions that you have, because we will try to address everything that we can. Now, without further ado, I will invite Mr. Khan to begin.
Thank you so much, Sherilyn. And thank you, AIADR, for this opportunity. So I've been asked to share my experience in India with the New York Convention and also cover the surrounding jurisdictions like Bangladesh, Sri Lanka, and Pakistan. Though I've not actively, practiced, but I'm an academician, so I do keep writing and reading on surrounding jurisdictions. So I'll be sharing my experience in relation to what I've understood from the judgments passed by the surrounding regions. Before I come to the jurisdiction, I will first like to touch upon the whole rationale of having New York Convention and signing the convention. So as you know that, it is one of the most important and widely adopted treaties in the field of international arbitration. And the primary objective of the New York Convention was to facilitate the recognition and enforcement of the arbitral awards made in one country, in other countries that are parties to the convention. Now, when we talk about India, India started very early in comparison to other hubs, the popular hubs like we see in Asia today. And in fact, India was one of the first few countries to adopt the New York Convention in 1960, as compared to Singapore, which adopted the same in, I think, 1986. But I mean, I'll draw a comparison later. But Bangladesh, I think, ratified the convention in 1992. They were a little late. And Sri Lanka signed in 1958, ratified in 1962, pretty much the same time when India signed it. But Pakistan signed it in 1958 and ratified in 2005. So they were pretty late in ratifying the convention. Despite all this, Singapore stands out as one of the leading centers for international commercial arbitration, and in fact is a preferred hub for a lot of investors who want to invest and do arbitrations seated in Singapore when they have to choose a seat. The reason why in such a short span Singapore has emerged as a hub of international arbitration alongside popular arbitration hubs like Paris, London, Geneva, I think the credit goes to the Supreme Court of Singapore that has upheld arbitration agreements, enforced foreign awards, and construed public policy narrowly. And also the government of Singapore that has ensured world-class infrastructure and is known for its competence and integrity. Now, every country aspires to become the center of arbitration or a hub of arbitration, the popular term we are using these days, owing to various benefits that it entails. Also, every country wants to get more and more investment, but the investors take a note of various factors before investing in any jurisdiction, such as whether the country has a robust arbitration mechanism, or whether the courts and the government of that country are arbitration friendly or not, or whether there is an ease of doing business and a stable environment for business or not. Now, the topic, all of this I am discussing because the topic is that whether New York Convention in India and neighboring countries a paper tiger or an effective enforcement mechanism. I think there is no direct answer to this question because it completely depends on the perspective and the context in which this is being assessed. Now, even though India incorporated the New York Convention into the Indian law of the Arbitration Act 1996, the act was enacted to provide a robust legal framework and to make arbitration more investor friendly and to make India look like a jurisdiction which is investor friendly or pro enforcement approach was being adopted by the courts in India. That was the whole rationale behind coming up with a law of the 1996. But the act suffered with various challenges, the 1996 Act. One, of course, was there was a delay in the enforcement of foreign awards. Every now and then, even though we were a signatory and we adopted the New York Convention, the situation in India was pretty bad in the 1996 Act. And there was too much of delay happening in the enforcement of foreign awards. And the other challenge that India faced was the excessive intervention by the courts. Though the whole rationale of Arbitration Act of 1996 was minimal court intervention. But we were seeing, after the 1996 Act, that there was a lot of intervention by the Indian courts, even in foreign awards. So in true sense, it was defeating the purpose of the New York Convention. Until 2015, when the law changed. I think on 23rd October 2015, when the new law came, which was an amendment to the 1996 Act, much has changed since then. I think India has done an excellent job, and it's actually making New York Convention also becoming a very effective enforcement mechanism. Now, why I'm saying so? What are the steps that India took that actually made it stand out, amongst other regions which are surrounding? So one is that India has taken steps to align itself with the arbitration laws of the other country, with the best practices which are being there in the other jurisdiction, and also to promote a pro-arbitration approach. And that is why the amendments of 2015 were brought in. One such example of those improvements was when they said that if you want to challenge an arbitral award, the ground of patent illegality will be available for domestic arbitrations, but the ground is not available for foreign awards, thereby reducing the interference and narrowing down the public policy exception in line with the New York Convention and making it easier to enforce the foreign awards. I think that was a very big push given to the pro-arbitration approach. The other thing is, if you look at the last 10 years, the way after 2015, last 8 years, in fact, the way judgments have been enforced, the foreign awards have been enforced by the Supreme Court of India, a very positive message has gone. I can give you a series of judgments, but I know we're running against the clock. But except one judgment, which was NAFED versus Alimenta, wherein Supreme Court refused to enforce the foreign award, I think as a matter of rule, the Indian Supreme Court has adopted the pro-enforcement approach. Yes, in some cases, there has been some delay in enforcing the foreign awards, but we have come a long way. And I think the Indian Supreme Courts have done a phenomenal job. The other thing is that recently, for instance, the Indian Delhi High Court has passed a judgment on third-party funding. So I think these kind of things are coming wherein they are recognizing these best practices internationally and making themselves look like a jurisdiction which is pro-arbitration. Another example I can give you is Amazon judgment, wherein the Supreme Court of India recognized and acknowledged emergency arbitrations. And even though there is no mention of emergency arbitration under the Indian law, but the Supreme Court took the pro-arbitration stance and said that party autonomy is the brooding spirit of arbitration. And that's how, minimal intervention by courts is happening, and India is doing an excellent job. Another thing where India has done exceptionally well is on the institutional side. In 2019, amendments were brought in wherein they realized that now India needs to push institutional arbitration, and ad hocism needs to end. And that is why, to promote the culture of arbitration as a preferred mode of dispute resolution, Indian government as well as Indian courts have started pushing institutional arbitration. One such example, of course, is the center which we are heading, which was started by the then Chief Justice of India. And this is called International Arbitration and Mediation Center, Hyderabad. To give you an example, because in international conferences, when you talk about India, mostly you will see people criticizing and saying courts keep interfering, it is unpredictable, not investor friendly. But I must tell you that, being a center in Hyderabad, the place where our center is located, we are administering disputes of about $800 million. Now imagine the progress, and we are administering more than 35 cases already. So a new institution which has finished a year and few months has been able to do well. So I think that culture is growing in India. We are pushing towards institutional arbitration. New institutions also are coming up in India, and they are being pushed by the government as well as by the courts. So I think to a large extent, public policy exception will not be attracted when institutional arbitration is involved. But when I talk about Sri Lanka, because India, I've given you pretty much an overview what Indian government is doing. If I talk about Sri Lanka, I think, became a party to the New York Convention, and they adopted in their Arbitration Act of 1995. Few provisions were incorporated for recognizing and enforcing foreign awards. Now, although arbitration has been expressly provided for by the statute since the 19th century in Sri Lankan courts, they have at intervention. To give you an example of a Sri Lankan court where they have actually acted in line with the pro-enforcement approach of the New York Convention. One such example would obviously be the case of lightweight body armor versus Sri Lankan army. The Supreme Court in this case overturned a judgment of the High Court that set aside an arbitral award on the basis of finding that tribunal had arrived at an incorrect decision on the merits and that the award was against public policy. So basically, Supreme Court of Sri Lanka employed a narrow definition of public policy and said that it will include instances such as corruption, bribery, and fraud, and similar serious cases. So that was the rationale given by the Supreme Court of Sri Lanka, which I think was a very positive step. And in early 2022, I think there was a discussion regarding amending the law and bringing in line with the best practices. Now, lastly, coming to Pakistan, because I think I have my time has exceeded. So quickly, I'll touch upon, what is the situation in Pakistan. Like I told you, they ratified the New York Convention pretty late, but I think they need to come out with strong and predictable public policy mechanism. For example, the Lahore High Court, in a very recent case of Jess Smith versus DS Industries, they did not adopt a pro-arbitration approach. So it is important that Pakistani courts also become conscious of their role in maintaining Pakistan's business reliability in the international market and shun any kind of attempt that may undermine the public policy. Lastly, I feel that even though New York Convention has been doing excellent now in India and the surrounding jurisdiction, the times have changed. Earlier, the position was pretty bad, but there are still some challenges. One such example that I can think of is that the way public policy has been interpreted by various courts in different jurisdictions. And the second problem that I see is that though New York Convention does talk about enforcement of foreign awards and recognition, but it does not talk about the other aspects of arbitration, like arbitration agreements. So at times in various jurisdictions, the problem is not the awards, but the arbitration agreement itself, is not being enforced and being challenged on grounds of existence or validity. So I think there are a couple of issues, but I think before I exceed my time, I'll let my other panelists shed light on this. Thank you. Thank you very much.
Thank you, Tariq. I think now we turn over to Dr. Nasser Mazen Al-Atba. When you're ready, please.
So thank you very much for my colleague. Thanks, Shirlin, and thank Mr. Tariq Khan for your insightful introductions about what is India and Pakistan and Bangladesh position in regard to the New York Convention. Now, we are moving to the MENA region, which is the abbreviation of Middle East and North Africa, but I will go further for the other African states, which is considered to be an Arab states as well. So many of you, I believe, know what is the New York Convention about. It's about the recognition of the arbitral award. And most of the New York Convention signatories agree to recognize and enforce arbitral awards from other signatory states, meaning that satisfaction may be pursued in any of the legal systems of the signatory nations. The Convention's reputation for efficiency and impartiality has fueled the growth in commercial arbitration in recent years, making it vital to adjunct to international trade. Regarding the motto or the theme, whether it's a paper tiger or a very efficient tool, I am in support that the New York Convention is the most powerful tool in MENA region, or if not say, is the only tool to recognize and enforce the arbitral awards. We don't have any other regional conventions to enforce the arbitral award in this area of the world. The state of Qatar had acceded to the New York Convention on the recognition and enforcement of foreign arbitral awards by Emiri Decree number 20 of 2003 in force as of 15 of March 2003 and became an enforceable and applicable legislation. One of the prominent judgments to support the enforcement of the arbitral award is the judgment made by the Cassation Court number 358 of 2015. And in brief, the court held that the Qatari court has no right to refuse to enforce the arbitral award because the state of Qatar joined New York Convention, unless the litigant presents an evidence that the arbitral award has not become binding on the litigants, or it has been annulled or stopped by the competent court in the country in whose territory it was issued. That means that the New York Convention has linked foreign arbitral awards to the legal system of the country in which they were issued and decided the rule of jurisdiction of the courts of this country alone on the claim of the invalidity of these arbitral awards. And to give an overview about what Qatar did and to support the arbitral award, and mainly this is a message to all the litigants that the arbitration is very important to the Qatari courts. I remember that last year, the Qatari Cassation Court approved the arbitration clause, which is being transmitted by electronic means. While we have seen in Dubai, the Dubai Cassation Court says that the arbitration clause should be signed by both parties, and there is live signatures and the document that including the arbitration award. We have seen also there is some support by the Qatari court for the arbitration means by electronic means and emails. So there is a new law which is not being produced long time ago. It's law number 2 of 2017, which gave the same exactly how to set aside the arbitral award in the local court, and they copy pasted the Article 5 of New York Convention. So the last Middle East countries have recognized the New York Convention, most of them. Morocco and Syria among the first. They joined in 1959. Iraq, Al-Iraq is the latest till now, which joined in 2021. Libya, Yemen, and Somalia still not signed the convention. And to see how is that affecting those countries is to know that someone who couldn't enforce the arbitral award against Libya or Yemen and Somalia in their homelands, but of course they can enforce it in any of the signatory states all around the world if they have assets there. I think this is what I have in a brief for the MENA region, and thank you very much for this opportunity.
Okay, thank you very much. Now, moving on, we've got Mr. There we go. We've got Mr. Oliver Bulthausen. Please go ahead when you're ready.
Thank you very much. Pleasure to be here. Pleasure to speak about the European Union and Germany and the New York Convention, which would probably fill a day or two if we go through case law and history. But let me try and be brief. The question was, is it a paper tiger or an efficient enforcement mechanism? And I think you should ask yourself, what would enforcement of arbitral awards look like without the convention? What would it look like, or what does it look like in countries like Dr. Nasser mentioned, like Yemen or Libya, who have not signed the convention? And if we would not have that convention, I think the answer becomes clear. It is surely not a paper tiger. And in looking at Europe and at Germany in particular, I think we are very efficient and effective in enforcement of New York Convention requirements, and therefore it is an effective mechanism. So that's the starting point. The second element is you have to understand, if you see some critics and read about the New York Convention not being concrete enough and there's too much room for political influence, etc., etc. The issue which you are facing is that we have, I think Shona mentioned 172 signatories, and they come from tremendously different backgrounds and understanding on how law and how the judicial system should work. So the convention, just by its own right, needs a certain flexibility. And if you look at it, now 65 years old, and the issues have changed, the environments have changed, laws have changed dramatically in jurisdictions, and it's still there. And it's still a proven mechanism which has given results in a lot of jurisdictions. So it is a very solid and good mechanism. I would even go so far to say that nowadays, you would probably not get 170 signatories together entering into such a convention anymore. But we are lucky to have all the signatures done. Now, let me tell you a little bit about experiences and in the EU and in Germany. I also checked with my colleagues in Spain, Italy, Poland, and elsewhere. And we all agree that it has been a development over time where certain criteria have been ironed out by the national Supreme Courts or by the courts. And now it's a fixed system where you can rely on, where you can check your cases against. And it is quite predictable in the EU, especially also in Germany. But we would not be lawyers if we not argue about everything. And I just wanted to raise a few points where you can find a lot of case law on and a lot of developments on where people have argued about. So we start at Article 1 of the Convention. And Article 1 of the Convention applies to arbitral awards made in the territory of a contracting state, and so on, and so on, and so on. So the first question, of course, for a lawyer comes up, what is an arbitral award? Can I defend that this is an arbitral award, etc., etc.? And you will find nothing in the Convention. So it is up to the national courts to decide what they consider an arbitral award or not. The German courts were early on pretty clear that it needs to be made by arbitrators, resolve a dispute or a part thereof in a final manner, and be binding. These three elements were ironed out by the court decisions. And guess what? The lawyers come up and said, oh, well, wait a minute, what is binding mean in that discussion? So the next discussion on procedural orders, are there binding? Are there final manners? Are awards on jurisdiction of such kind? Are there cost orders to be enforced, consent awards? How is that to be dealt with? Well, German legislation and also throughout the EU developed over time a pretty clear view on this. And already in 1990, the German Supreme Court found a very simple definition and said, binding was what is not subject to an appeal either before another arbitral tribunal or a national court. And then there was a discussion if annulment proceedings, which we have, of course, also given at the seat, are considered of such kind. And the German courts was pretty clear that it says not to confuse with the annulment proceedings, which are a different animal than the appeal processes. Then the next question was, if there are interim awards, are the interim awards already binding enough and can be enforced? German courts were pretty clear early on. It says yes, if an award contains a binding decision on some of the claims capable of recognition and enforcement, they are in its own right. So also interim awards in Germany and most of the EU countries I looked at can be enforced. Next question, as we all know, it's New York Convention applies to foreign awards. So, of course, lawyers argued, what is a foreign award? And also here, the German courts were pretty clear early on and have determined that the only relevant criterion to be taken into account when determining whether an award is domestic or foreign is the geographical location where the award was rendered. So that's the only criteria. And I think UK, Netherlands, Spain, etc., Italy, all sharing that view that the geographical location where the award was rendered is the decisive element here. Then we have, of course, recognition and enforcement. And we would not be lawyers if we're not arguing, is that the same animal or can we have the one without the other? And there the German courts found in 1981, well, you could not sort separately enforcement and recognition. It has to be interrelated and is only to be looked at together. That's quite different from the US, especially the Second Circuit decided that you can have just a recognition of an award, for example, for a res judicata defense in another litigation. So the next was a case where an enforcement was sought and the other side counterclaimed with a setting aside request. So the German courts had to deal with that issue and found, no, setting aside and annulment is a different set of proceedings. It's not covered within this process and cannot be used as a counterclaim in enforcement proceedings. And then there's, of course, partial recognition. Can I only take out an element of an award, which I then put and enforce? And the German courts, as well as most of the European courts, if not all, found, yes, recognize and enforcement of elements of an award which are not impaired by Article 5 defenses of the convention can be done. I just showed you a few elements which showed that there's a development, and the flexible wording of the New York Convention need to be worked out and interpreted by the court. There was a question on limitation period. Until when can I bring a certain enforcement action? And that is, again, there's no limitation period for enforcing awards in the convention. So it's determined by the courts at the seat of the arbitration, or as we have here, the jurisdiction where it enforced. And in Germany, it would be 30 years for an award to be enforced. Then I would like to briefly touch upon the annulment decision. Article 6 of the convention, the court may adjourn recognition if an annulment proceeding and application has been put forward. An interesting animal, giving a lot of discretion to the national courts, finding a compromise between promoting the enforceability on the one hand and preserving judicial oversight on the other. This results in a lot of forum shopping, and interestingly, Dr. Nasser mentioned that the Qatari courts will accept an annulment decision at the seat of the arbitration and not enforce it any further. That is quite different in some of the jurisdictions. I would like to quote Italy, and I wrote it down here: an arbitration award, even if it's violating Italian law, can still proceed in Italy and results in an award to be enforced outside Italy. So they are parallel proceedings. Annulment and enforcement can go different ways. And that has been shown in the case of Hilmerton Limited versus Omnium, where the Swiss courts annulled a arbitration award, while at the same time, the same award found recognition in the French courts. So these awards go different ways, which allows you to do some forum shopping. The French courts, by the way, are quite strict on this. In 1993, they said the French courts are explicitly not bound by annulment decision of the Swiss courts. If there is any conflict, I don't know, but that was a quite outspoken comment. Last but not least, and I'm conscious of time, and probably you need to stop me because I have a lot of war stories to share on this. But Article 5, of course, there are different fair trial, enforcement refusal grounds, or public policy, the most famous one, because it's the most not defined term. At the time of the convention, even some said it's a mystery to some of the negotiators. It still is probably the most discussed one amongst the grounds for refusal. So public policy or ordre public or good morals, however it is stated in your country, it's not defined and does not have any guidelines. But the European Union is quite clear. There are two big elements of it. One is we're looking at the international public policy, not necessarily the local and national ones, and only severe violation of fundamental principles allow the rejection. And the French have it actually codified that way. And the second element is that the award must be based on the violation of fundamental principles of public policy and affecting the invoking party. So that is the criteria to be checked. Last but not least, I would like to shed some light on the fact that we cannot ignore political influence on that. In the case United World against Krasny Yakor, the Russian Federal Court refused recognition of an ICC award in Paris rendered against a significant Russian entity because it considered the effect of the award would be against public policy, because it would put the Russian entity into bankruptcy and have an adverse effect on regional economic stability. So the economic interest here in Russia, and we will see that because of the Russian-Ukraine conflict in many defenses, I will foresee, is the economic interest is an element of public policy. Same in China, decisions made in 2001 made that very clear. In Turkey and Indonesia, I found also case law on that, which is the total opposite in the EU. The economic interest and bankruptcy elements are not at all to be considered a reason or ground for public policy dismissal. And then last but not least, there is the famous fraud, corruption, and other cases. And the German courts were very clear, and we were involved in some of these defending an enforcement decision, that the sheer alleging of fraud or corruption does not live up to the standard. It needs to be strong prima facie evidence, and the evidence could not have been presented in the arbitration or in an annulment proceeding. So even if you have a strong feeling that there is something wrong, it should have been brought in the former arbitration tribunal, etc. And Germany made very clear, even clear misapplication of the law is not a violation of public policy. And that is shared by Switzerland, France, UK, Austria, etc. Different in other countries like the Philippines, etc. And I stop here because I do not want to steal too much time of my colleagues, and looking forward to questions. Thank you very much.
Thank you. And now, again, last but not least, Mr. Cronenberg.
Thanks, Charlene. Hi, can you hear me? Just to check.
Yes.
Excellent, thanks. Let me just get my slides on. Let's see, sorry. Yeah, I hope you can see that. Hi, thanks for having me here. And I'm going to be talking about the Singapore and hopefully ASEAN perspective in terms of the New York Convention. You'll see a little QR code there. If you scan the QR code, you'll get some of the resources, the cases that I'm speaking about in the next few slides. So from the Singapore perspective, I thank my colleagues who have said such wonderful things about Singapore. Really, we have managed to be very pro-arbitration, and we have, to the great credit of the people who put these laws in place, we adopted the UNCITRAL model law. And that actually provides a very, very strong framework for some of the concepts that we apply in arbitration in Singapore, alongside the New York Convention. So some of the ASEAN states that you will see have adopted the New York Convention, but are not UNCITRAL model law jurisdictions. So there's a little bit of a disconnect between the concepts that the convention has and their own domestic laws, which are not entirely aligned with the UNCITRAL model law. We've combined both the UNCITRAL model law as well as the New York Convention in our International Arbitration Act 1994. Both of those things, the model law as well as the convention, are reproduced in full as part of our International Arbitration Act. They are incorporated into the International Arbitration Act. As many people know, the Singapore courts are highly pro-arbitration, and they will recognize and enforce a foreign arbitral award made in a New York Convention jurisdiction unless there's an impediment, let's say under Article 5 of the New York Convention, which finds its way into Section 31 of our International Arbitration Act 1994. When I say pro-arbitration, I do not necessarily mean pro-enforcement. The two concepts are actually distinct. One does not willy-nilly enforce an arbitral award if there are good grounds not to enforce that award. And those grounds, for example, will be found in the New York Convention, Article 5. So it's not every single foreign award that should be enforced. It's only if that foreign award accords with the basics of arbitration, if I can put it down to those basics, where you have a valid arbitration agreement that's binding on the parties, and that's one that's enforceable, as well as a system of laws that will give force to that arbitration agreement. And I'm going to show you two examples of in the next slide where the Singapore courts have actually refused enforcement of a New York Convention award. Enforcement and recognition in Singapore is done fairly quickly, fairly easily. The winning party takes the award and makes an ex parte application, which means the other side is not there. The filing is done in the Singapore courts. The Singapore court then looks at whether there is a valid and binding arbitration agreement, whether there's an award, a reasoned award as a result of that arbitration agreement. And this is a mechanistic approach. And if the court feels that those two boxes are ticked, then the court allows the recognition and enforcement. An order is made, and the order is then served on the losing party. And the losing party, if served in Singapore, has 14 days to come back and say, please do not proceed with the enforcement. Or if it's overseas, has a longer period, could be 21, could be 30 days, depending on what the court orders, to come back to the Singapore courts to explain why recognition and enforcement shouldn't proceed. If they don't do that, a judgment is entered in the Singapore courts, and it can be enforced just like any other judgment of the Singapore courts. So it's a very fast process. It can happen within a matter of days or weeks at the most. These are two examples of rare refusals of enforcement in Singapore. The first is the Sanam case, ST Group and Sanam. This was a case where the tribunal decided that the seat of the arbitration should be Singapore. The Court of Appeal in Singapore, when it was asked to enforce the award, found that the proper seat for that arbitration was not Singapore, it was Macau. And because the arbitration was not conducted at the seat that should, the proper seat, the seat that the parties had effectively chosen, the court refused to enforce that particular award. Again, you'll get copies of these cases in the QR by scanning the QR code that you saw right at the start, and you'll see it again on the last slide. The other case is CVG and CVH. If you're wondering why these cases sound so weird, we've anonymized the names of the parties in Singapore. It's making it extremely difficult for law students to remember arbitration cases because they all sound like ABC versus XYZ. This was another case where enforcement was refused. This was an award made by an emergency arbitrator in Pennsylvania, and the court in Singapore found that one side had been hampered in the presentation of its case and therefore refused on the grounds of Article 5(1)(b) of the New York Convention to enforce that award. Again, these cases are very rare. If one were to trawl through the database of cases involving the enforcement of foreign arbitral awards in Singapore, you'd find practically these two cases. Every other case that we know of has resulted in an effective enforcement. I'm just going to go on to ASEAN now. So ASEAN is the Association of Southeast Asian Nations. It comprises 10 countries. Those are the 10 countries there. And all these 10 countries, Indonesia, Malaysia, Philippines, etc., all these 10 countries are New York Convention countries. And theoretically, enforcement should be very easy in all these different countries. But in practice, the first difference is really the difference in the speed or the ease of enforcement in these countries. Of these countries, apart from Malaysia, Singapore, and Brunei, the other countries are civil law jurisdictions. They have their own processes, and not all these countries are model law countries, which means they have their own domestic laws on arbitration with their own understanding of arbitral concepts, which may not be entirely aligned with model law concepts. So the speed at which things progress in these different jurisdictions varies quite drastically, if I might say. For example, in Indonesia, they still require that the arbitral tribunal grant grant a power of attorney rather to a lawyer who then registers that award, and then you need an order of exequatur in order to enforce that award in Indonesia. All that takes quite a little bit of time. Some ASEAN states, as I said, are not UNCITRAL model law jurisdictions, so there's no harmonious understanding of certain arbitral concepts. For example, the doctrine of separability. In the model law world, we understand that the arbitration agreement is separate and distinct from the matrix contract in which that arbitration clause, arbitration agreement is found. This is not necessarily the case, for example, in Indonesia, which is not a model law country. The good news is, as I understand it, Indonesia is moving towards becoming a model law country, and several other jurisdictions are already model law jurisdictions like Vietnam. There is no also harmonious understanding of New York Convention concepts in ASEAN for the same reason. If you already have a common understanding of certain concepts like the arbitration agreement, what's an arbitration agreement, what's final and binding, as my colleagues have mentioned, because you're model law jurisdictions, it makes things a lot easier. Some examples of the lack of harmony between ASEAN jurisdictions are as follows. Agreement in writing. So the New York Convention doesn't talk about electronic communications. Those things never existed when the New York Convention was first promulgated in 1958. It talks about telegraph or telefax or something like that. I don't think it even talks about telefax, it's telegraph. Many people won't even understand what that means nowadays. So the question is, if you have an arbitration agreement confirmed through an exchange of electronic communications, let's say an email, does that amount to an agreement in writing for the purposes of the convention? We don't have exact harmony across ASEAN member states. Then we have Article 5.2a of the New York Convention, where enforcement can be enforced if the subject matter of the difference is not capable of settlement by arbitration under the law of that country. Different jurisdictions have a different concept of what is resolvable by arbitration and what isn't. And I dare say it could come down to a question of politics sometimes, and a question of the temperature in the country as regards arbitration, whether arbitration is treated warmly or treated coldly. Because of certain developments, you might find an arbitral award made against a certain country, and then that country says, well, you know, anything involving state land, for example, or state asset is not capable of being resolved by arbitration. And then obviously enforcement is going to be blocked. The other point that my learned friend has mentioned from Europe is Article 5.2b of the New York Convention. Recognition and enforcement of the award would be contrary to the public policy of that country. What is public policy? Is public policy narrow, as we understand it in Singapore, encompassing issues of fraud, corruption, that sort of thing? Or is an arbitral award that again deals with state land, a state asset, or even perhaps, if you extend it to its illogical end, an award against a national of the state? Is that against public policy? That again is a function of time, political climate, and then we have different understandings of that term, therefore, throughout ASEAN member states. But here's some good news. We have something called the ASEAN Law Association that was established in 1979. This is a picture from the Governing Council meeting in 2021. You may recognize some of the people on screen here as being rather famous judges or jurists from around ASEAN. And the ASEAN Law Association has come up with a paper called Recommendations, Best Practices, and Non-Binding Guidelines on the Enforcement of Arbitral Awards within ASEAN. Now, this, of course, is just a paper. It's a work in progress. It's currently under discussion. And it was first prepared by the ASEAN Law Association in 2020 for consideration by the ASEAN Law Ministers Working Group that was set up to harmonize trade laws within ASEAN. And this paper aims to address difficulties within ASEAN in at least 3 areas pertaining to the New York Convention. First, agreement in writing, trying to fix that a bit of ambiguity in terms of electronic communications. Certification or authorization necessary for enforcing an award. You need a duly authenticated award. Who do you go to do this? What's the cheapest way of doing this? What's the fastest way of doing this so that let's say, an award made in one ASEAN member state can be enforced quickly in another ASEAN member state, and proper translations of the awards. Who can do this? Is there a central repository? Imagine the difficulty trying to translate something from Thai to Lao, or Thai to English, or Indonesian to Vietnamese. So this is a very good start in my view, but it still leaves open the issues of arbitrability and public policy that I spoke about earlier. Understandably, these are very difficult to resolve, and they, again, touch on a bit of politics. As far as ASEAN is concerned, my own view in terms of whether the New York Convention is a paper tiger or not, it's certainly not a paper tiger. It is working to some extent. It's working at different speeds in different jurisdictions. It is easier to enforce an award in certain jurisdictions than others, but we're certainly moving towards some sort of harmony. But the New York Convention certainly could do with a lot more bite. We need to harmonize our ASEAN member states' understanding and application of key concepts like agreement in writing and public policy and arbitrability. We need to make enforcement more readily accessible. Translations, maybe even using a common language where ASEAN, if you have an arbitration seated in an ASEAN state, you get the award in the language of the arbitration as well as in English, so that it can be easily transported to another ASEAN member state where it can be enforced. And we also need to try and make the process of enforcement easier. I'll give you an example. You would think that, let's say, an award seated in Singapore, a New York Convention jurisdiction, would be easily enforceable in Vietnam and easily in a New York Convention jurisdiction. The answer is yes, it is more readily enforceable than a non-New York Convention award. But if you have a Vietnamese award, let's say a VIAC award, you don't need to go through any sort of court process. You take the award, you go to the governmental agency that enforces awards, and it is enforced. That same process is not available to New York Convention awards from outside of Vietnam. So that is something to think about. Can we make New York Convention awards as readily enforceable as domestic awards in certain jurisdictions? We're trying to do that. And with that, perhaps the New York Convention won't lack bite. It will be a real tiger. Thank you very much. Those are my thoughts. Again, scan the QR code if you like the resources. Thank you for listening.
Okay, thank you. So I think in accordance with the schedule that I've been provided, we now all get to take a 10-minute break where the audience is going to think of very insightful questions and type it into the chat box for me to spread the love. I guess unless somebody tells me otherwise, let's reconvene at 10 minutes past 4 Malaysia time.
Yes, Ms. Sherlyn, we'll see you back in 10 minutes.
Wonderful.
I believe that the break is now over. So, Ms. Shirley, we can now begin the Q&A session.
That would be great if I have Tariq back. There we go. At least the speakers all came back. I'm going to also assume that all of our participants have stayed, but I don't see any questions yet raised by the participants. Do we have any questions that somebody would like to relay? You can put it in the chat box, put it in the Q&A section. You can even do it anonymously if you don't want me to call you out. And if you don't, it's okay, because I've got a bunch of questions. I mean, all of the presentations today were extremely insightful, and I can see why perhaps our participants are a bit overwhelmed, because there was a lot of information, but good information. I kind of jotted down one or two questions for each of you. So I'm going to kind of start with Tariq, if you don't mind. If you don't know the answer to this question, you can tell me. It's actually kind of curiosity for me. I don't think you mentioned it exactly. I didn't hear it, but I heard it in subsequent presentations. The average time period for an enforcement proceeding and for enforcing an arbitral award in India, international arbitral award, after this change in 2015. Because I know before we have nightmare stories of years and years of enforcement, and some of those are still going on.
Yeah. No, so after 2015, I think most of the cases, there's no hard and fast rule that, the time period will be 2 years or 1 year or 6 months. But in my experience, in cases where we have appeared before the courts, because we were involved in a couple of other matters where we were representing foreign clients. So the approach has been very positive, and sometimes within a year, you are able to see the results. You're able to see the color of the money. But sometimes, yes, the maximum time that I'm seeing is 3 years, is what I will say on an average.
And in India, so how does the process go in India when the award is enforced or not enforced? Because, for example, in China, a court cannot actually deny enforcement of an international award until it goes all the way up to the People's Court. Is there something similar in India, or is it if it's rejected, it's...
So in India, so every foreign award is governed under Part 2 of the Arbitration Act, which is completely dedicated to foreign awards. Part 1 is about the domestic arbitration. Now, under Part 2, just like I said, the scope of interference is also very low, because patent illegality is a ground which is not available. But still, for every award which comes from the foreign seat, has to be recognized and enforced first under Section 48. So there is a test that you have to get that recognized and it should not be in bottom line is that it should not be in contravention with the public policy of India. So that is the only test that it has to pass. And as long as that part is taken care of, your award will be enforced. The court has been very, very pro enforcement. And the only problem that happens is when the other side is, playing some tactics and not submitting the money, showing themselves and so XYZ. I don't want to get into that. But otherwise, from the courts, the orders and all I have seen coming that, the deposit has to be made, the money has to be released, attachments happening, all of that happens in a timely manner.
And just out of random curiosity, what's the longest you've ever seen for an award to the process for enforcement in India? And don't lie.
So prior to the amendments, I think previously there were cases which are going on for almost a decade. So I think that was, the sad part, because a number of appeals were there. They were being interfered by Indian courts on very small and technical issues. I think that's when the approach was different. But I think now I can say that, we are at par with every other jurisdiction. And soon you'll see, better days coming with, the Supreme Court judges giving very positive messages. And the law has tweaked quite a lot in favor of investors, and party autonomy has been pushed to a large extent. In fact, currently we are having a committee which is looking at the law, and we are still trying to make it even better, because the present law is working absolutely wonders for us.
Okay, thank you, Tariq.
Thank you.
I'll come back to you later, don't worry. Who do I want to pick on next? I'm going to change it up a little so it's not in the same order. Oliver, you're probably actually going to hate me. This question is either going to be very brilliant and well thought out, or make absolutely no sense. Feel free to tell me whichever one it is. But the one thing really about Europe right now that I'm sure you are getting pounded with questions, whether they're valid questions or not. I mean, with the ECT issues, with the brilliant ACMEA case that continues to haunt everyone and everywhere. I mean, do you see issues? I mean, you discussed Germany, you discussed, Spain, Italy, even the UK, but we kind of stayed away from these I guess, treaties, the ECT and the ACME decision, but I mean, they have an influence, or there is some type of a connection with the New York Convention. Do you see perhaps a drop in arbitration involving one of the laws of the EU, or involving 2 EU countries or companies from 2 EU countries?
Well, it is a brilliant question, because you can talk days about it, and probably you have done your research homework and seen that we've been involved in some of the cases. So Comstroy and ACMEA are very famous cases. But to the present day, I have to say that these are focused on treaty arbitration practices. So when a government, a state is involved, the question is there a regime which in that treaty has the EU becoming independent member of that treaty, and thus not the individual state having its own right, but intra-EU disputes have to be dealt with at the European courts and not in arbitration. And there has never been an arbitration agreement. I think that is a political driven, personally. I think it's a political driven decision. It is dogmatically flawed, but we will not change that. Do I think the New York Convention get influenced by it? I don't think so. I think the New York Convention, especially in the commercial arbitration field, will stay independent of it. It does not have an influence on that, because we don't have that treaty scenario where the EU, as whatever as it is, as an organization, a group of countries, can join in a convention or a treaty. So yes, it's an issue. Yes, it is probably also from a dogmatic point of view concerning, but I don't think it has any influence on the New York Convention and the enforceability in the EU.
You handled that well, and I like that you thought my question was brilliant. I will also come back to you, but I actually have a question from the audience. So let's read this. Obviously, thank you all for the interesting presentation. It seems to our wonderful participant, what's been said, that courts of most jurisdictions have already put quite some effort into interpreting the New York Convention. Mr. Cronenberg also mentioned in particular the active harmonization efforts of ASEAN countries to achieve a more uniform approach to the New York Convention. In your opinion, to avoid forum shopping, would harmonization be something that could or should be achieved internationally by adopting the New York Convention itself? Edmund, I'm going to send this first to you since you got quoted in there.
Okay. I think the basic principle is that you can't amend an international treaty without the parties all agreeing to amend that. So right now, you're going to have to get 172 parties to all agree to change the New York Convention. And when I say change, add in definitions, add in common understandings, whatever you want to do to make things easier amongst those 170 odd countries. One of the reasons why, in my view, there are 172 states parties to the New York Convention is because the New York Convention is very short, it's very flexible, it is very general in many areas, it can be interpreted very widely by whoever signs it. And of course, you can make reservations to certain parts of the New York Convention as well. It is an international treaty made between countries. So if you want to amend it, I think in the first place, it's been a while since I looked at the Vienna Convention on treaties. So there is another convention that deals with international treaties, multilateral treaties. I think it's Article 40 or 41, something like that, of the Vienna Convention that deals with when parties can agree to amend a treaty. And it also provides that certain parties to that treaty can agree to amend as between themselves that treaty. So that may be a different way of doing it. Now, in a wonderful utopia ASEAN situation, all the 10 member states of ASEAN get together, they make an additional treaty, a convention, to give more guidance on the interpretation of those things in the New York Convention. Wow, that will be fantastic, but I'm not holding my breath. It may not happen in my lifetime. All right, so it's a bit more difficult for us to do that.
Just to see, does anyone else want to chime in on our participants' question? If not, I can happily move to Nasser. Oh yeah, there you go. Thought I forgot about you, huh? No, I did not. This is just actually one curious question. I don't know if you know the answer, but only because you raised it. Do you know if Libya, Yemen, and Somalia are considering signing the New York Convention?
Well, I do believe that Libya and Yemen and Somalia, they are among the non-stabilized states for the time being, and that might be the turmoil that they had before and the changing of the regimes. Somalia, they have the problem with the northern part of it. But I do believe that Libya might move faster than the others. Libya, they have now the central government. There is I do believe that there is the current prime minister has an engineer background, so he is well educated, and I think he worked also in the hydrocarbon sector, which is advanced among the other sectors in Libya. So I do believe that they will do like Iraq. Iraq is joined in 2021. And Iraq, they have the same problem. But I do believe that Libya will join shortly. And by the way, I have attended a big arbitration conference in Libya 4 months ago. And it's been held by the central government and under the patronage of the prime minister himself. He's the guy who is making the first speech and introduction. And I was very happy to see Libya moving toward the arbitration. And don't forget that there are some tensions between the local courts and arbitration in the MENA region. Local court at recent times seeing arbitration in a very cautious because the judges a long time they believe that this is their powers to finalize the dispute between the claimant and respondent, and to see someone who is not judge and has no judgment background, maybe they are an engineer or an accountant or no lawyer background or no law background, and making a judgment. Sometimes it is dragging the eyes of the judge to see where is the problems in the arbitral award itself. But for the time being, I can say, and I am confident that most of the GCC states, I mean the Gulf states, Saudi Arabia, Qatar, Oman, Emirates, Kuwait, Bahrain, most of them are toward the pro arbitral award. Qatar, for example, we have in Qatar only the appeal. If you need to make an annulment against an arbitral award, you can't go to the cassation. It's just the appeal court, and that's it. That means they need a speedy recourse to the finalizing either to set aside the arbitral award or to enforce it. Hope this answer you.
Yes, and I just had actually one more question that was in relation. It's not necessarily it could be the New York Convention, but it's more from my experience when I worked at the ICC. To be honest, every time we had a case come in that was seated in Qatar, we always had, when we reached out to the tribunal before we could confirm them, we had to ask whether or not they were able to travel to Qatar to sign the award once it got to that point, because at the time there was the requirement that all final awards had to be signed in Qatar in order to be enforceable. I'm looking at the look. I was just kind of curious with the whole COVID situation. Is this still the case, or is this something that, mind you, my time at the ICC now was over a decade ago. So this could also be very out of out of time.
Well, what do you mean by traveling to Qatar? You mean the physical signature?
The physical,
No,
so what we had to do back then, and this was a long time ago, they physically had to sign the award in Qatar.
No, this is not the case anymore.
That's good.
And can I ask you when was that?
When
long
I was at
time?
the ICC working with these cases, 2011 to 2013. And they were
Well-
also very particular construction cases. 500-page awards, not fun.
Well, we have still this trends of the construction matter, especially after the World Cup in Qatar and all the developments that happening the last 12 years. But no, that's not the case anymore. As I told you, that we have, me personally, I was the advocate for a very prominent case that the court of Qatar approved the arbitration agreement that been sent by electronic means. There is no signature on it. So you are the contractor. I am the main. You are the subcontractor. I am the main contractor, and I send you the terms and conditions by email, and the terms and conditions including an arbitration award, arbitration clause. So we went to the LCIA in London. We have got the arbitral award in favor of the client. The other party, the defendant, they open a case to annul, to set aside and annul the arbitral award. The appeal court, they said clearly that since you received the email, which is including the arbitration agreement, and you have done the job that's being required by the email, then this is an implied acceptance to the arbitral award. And that was an amazing award, actually, that opened a lot of discussions on the side that the court took to support the arbitration agreement, and but they said the support of the enforcement of the arbitral award that came from the London Court of International Arbitration. So no, to answer your question, I do believe that electronic signatures, but there should be a signature at least in the arbitral award to be enforced in Qatar.
Good to hear. I was starting to get curious what happened during COVID times. Okay, so I know I'm a little bit over on time, but if our wonderful hosts will bear with me, I just have one more question that I'd like to ask to each of our speakers today. Jason, you nodded your head, so I'm going to take this as a go. So arbitration, New York Convention, every single one of you mentioned at least once or multiple times that public policy prompt. And we all know as practitioners, perhaps you're going to correct me if I'm wrong, the likelihood of this challenging an arbitral award or not enforcing it due to public policy is usually quite low, usually about 1% or less. However, if each and every one of you, and I hope this is the case, sign up for moot court competitions such as the Vis East Moot Court, which I expect every single one of you to take part in next March in 2024 in Hong Kong. All the students, all the teams, even Vis Vienna, all 400 schools always argue that public policy is a huge thing. So I would just like to kind of pick your brains. In your experience, realistically, have you ever had a case where you've successfully argued public policy? What was it? Or alternatively, have you had a case where you heard a public policy argument and you literally were just like, really? I'm going to pick on, well, I've got Tariq up on the screen with me, so you get to go first.
Did you take my name to go first?
You were on the screen with me in front of me.
Sure.
So you get to go first.
Yes. So interestingly, I mean, in every matter that I've appeared in different high courts and Supreme Court, every matter, every award which is challenged has public policy ground, because that is the only ground on which you can set aside. So whether there is a legitimate case or not, whether there is any ground or not, people take all kind of exceptions to it, because I mean that's the whole problem, because countries have interpreted these grounds broadly, or they have sometimes added additional grounds in judgments for refusal in their respective national laws. So making enforcement more challenging in their respective jurisdiction. So there are a couple of judgments which were passed in, I think, early 2000, where the scope of public policy was expanded in such a way by the court. I don't want to name the judgments, but you can easily find it in my articles where I've criticized a couple of judgments. They used to take everything, something like any reasonable or prudent man should not look at it like that, and things like it is against the basic tenets of morality. So basically making it inclusive, and judgments to that effect were being passed in early 2000s. So I think that was quite absurd for me, to be honest, because I think public policy should be construed very, very narrowly, just like I said, Sri Lankan courts did, like corruption, fraud, those kind of things. And every country may look at their own definition of morality, etc. But I don't think those grounds should be permissible. But yeah, in India, almost every case which is there where a ward is challenged, you will find people raising all kind of grounds for public policy. You're on mute, Sherilyn.
See, this is how great I am with Zoom. Tariq, that was very interesting. Thank you. I said, Oliver, I'm going to now jump to you next.
I think rarely we'll find those cases. Nevertheless, there are a few groups which you come across. One is fraud, corruption, and related. Of course, the burden of proof is a big element there. So just the alleging, we have been involved in the case with Iran, where the other side alleged because it's Iran, they are on the corruption list very high. There is a likelihood that the agreement was under corruption. The court kicked that out because there was no prima facie evidence and such. There are nevertheless a few cases which are interesting. I think in Austria, there was a case on excess interest and policy of penalties. So punitive damages coming from an award might be an issue in the European Union because it's not within our judicial system. And then there are the famous antitrust-related cases where the European Court of Justice and also the US Supreme Court, they jump in every time where an award would give rise to concerns with regards to antitrust issues. So we see these groups, damages, excess damages, antitrust related issues, and then the whole fraud and corruption elements.
Okay, so nothing too extreme, but the punitive damages always gets me because in the US we love punitive damages.
Of course.
Edmund, what about you?
In a nutshell, public policy arguments in Singapore probably not going to work unless you have clear evidence of fraud, corruption, that sort of thing, what Oliver mentioned. ASEAN-wise, I have seen an interim, in fact, I think this was yes, it was an interim award. There was a question of whether or not it was really an award because it didn't really dispose of the merits of the case, but it was a jurisdictional decision, which was which also had an anti-suit injunction against certain Indonesian individuals, which the winning side then took to Indonesia in the Jakarta courts. And the Jakarta courts refused enforcement on the grounds of public policy because it was against, according to them, public policy for the tribunal to order Indonesian nationals not to pursue a case in Indonesia, in the Indonesian courts. Basically, the anti-suit injunction was against public policy. If you're trying to understand that, I'm trying to understand that too. But that was the position taken through a very different lens. And again, it's a question of whether that was really an award because it was not a decision on the merits.
That's an interesting one. Thanks. And last but not least, I haven't forgotten you, Nasser. Anything for us to hear? Anything?
Yeah, so I would join my colleagues here on the public policy. I would add one thing is in MENA region, or specifically to speak in the Islamic states, anything which shouldn't be arbitrated or to be under the arbitration, to be under the arbitration under the Islamic Sharia is against the public policy. So you couldn't make an arbitration agreement on selling alcohol, for example, in Qatar, or selling guns or weapons away from the corruption matters. And this, so anything that you couldn't make an arbitration clause, then this is against the public policy. We have one interesting case that there was a construction dispute and the engineering office wasn't registered in the ministry. So to be an engineering office, you have to go and register yourself in the Ministry of Municipalities. And because of that company is not registered, the claimant, the defendant, argued that this is against the public policy of Qatar because all the engineers' office to be registered. We rejected that based on the Estopel argument, and that is not justified because you already signed an agreement and we have cutting your services, and you breached the contract and you did not bring the service very well. So the Court of Appeal rejected their argument on the public policy. They said, no, you have signed an agreement away from all the legalities to register in ministries. You have done, you are in a commercial relationship, etc., etc. And I'm going to recall a very famous case regarding the public policy, which is Soleimani versus Soleimani. And that is regarding smuggling drugs in UK between a father and a son. So the English courts in this famous award, they annulled the arbitration based on the public policy that the Britain did not allow to smuggle drugs from Iran based on sanctions. Yeah.
That was interesting. Okay. Well, I have to thank Jason for, I know, Jason, you're looking at the time, but, you know, at least we had a very interesting discussion going and everything's going live. Thank you again to all of our panelists. Thank you to the AIADR for having us today. I'm not doing the closing, I don't think, so I'm going to now allow whoever is supposed to be doing the closing to do your thing.
Thank you, Sherilyn.
Thank you so much, Ms. Sherilyn. Before we part ways, on behalf of AIADR, I would like to sincerely thank our moderator and speakers, Ms. Sherilyn, Mr. Oliver, Mr. Nasir, Mr. Tariq, and Mr. Edmund, and of course the participants for taking your time out of your busy schedules in attending this talk today. It was very insightful and very informative. Let us now take a photo together with the speakers and the moderator, and I will pass to my colleague to do that. Yeah.
All right, ready? 1, 2, 3. All right, thank you so much, everyone. Once again, thank you, speakers, and thank you, Ms. Moderator, for joining in and making this a really interactive session. It was really beneficial. I think I cannot speak just on behalf of the participants, but even us at the Secretariat, we've got to see a lot of perspective from different regions and to know their developments. So it was really something eye-opening for us. So thank you so much, everyone. Have a nice day. Bye-bye.
Have a wonderful weekend, everyone. Thanks for making it fun.
Thank you. Bye-bye.
Bye.